All right, it's 5 o'clock. Everyone, welcome to our webinar today. Everyone's line has been muted automatically upon entry. If you have a question, please unmute yourself, but remain on mute otherwise. Larry, Paul, I'll hand it off to you.
Thanks very much, and welcome everyone, and thank you for taking time out of your busy days to dial in. Before covering what was actually decided at last week's meeting of the Valuation of Securities Task Force, which for convenience I think I'll call Task Force, it might be useful just to set the stage of how we got to that event. About the middle of last year, the NAIC, through its SVO, Securities Valuation Office, started to express increasing concern about a variety of transactions which they thought were abusive, and the abuses in particular that they took issue with were the fact that in certain transactions, non-admitted assets had been repackaged and had been brought back into insurance company balance sheets. And then more generally, the SVO expressed concerns that the ratings which were obtained in respect of these transactions didn't fully capture the risks of the underlying and related investments, and they accordingly began to express interest in taking away the filing exemption for these types of transactions and to subject them to the requirement that they be filed with the Securities Valuation Office for designation and the resulting risk-based capital requirements. It was relatively general, not terribly well defined. The SVO produced a definition of what they called principal protected notes, which they thought included and covered the transactions that they found to be abusive. They exposed that for comment. The industry responded with comments. There were 3 or 4 letters from various parties. I think it would be fair to say they generally took issue with the breadth of the proposed definition. They thought it was overly broad. They thought that the definition as originally proposed exposed the industry to unintended consequences. And in response, the SVO agreed to take the matter under advisement, to consult with representatives of industry, and to produce a new version of the PPN definition. The PPN definition was revised and was released by the SVO through the task force in February of this year. That was in the expectation that the PPN definition would be considered at a meeting of the task force, which was scheduled for the NAIC's annual meeting in Phoenix in March. Obviously, COVID-19 intervened, and that meeting didn't occur. The SVO had an intervening telephonic meeting at which they agreed to take the PPN definition proposal back up, and that was then scheduled for last Thursday's meeting. I think before turning over to Larry to go through exactly what the task force did, I think I would note there are a couple of features of the proposed definition that make it quite awkward. It has a relatively straightforward structure if you have A or B or principal protected note. Then there are some specific exceptions, one of which, an important one of which, is if you're a broadly syndicated securitization, you're excluded from the definition of principal protected note. However, you're brought back into the definition of principal protected note if you have a transaction that falls within one of the examples that are included in the definition. And after Larry has finished giving us a recitation of what happened at the meeting and what actually is now to take place, perhaps we could revert and talk about some of the issues that clients are likely to face as they actually work through the definition. So with that general introduction, I'm happy to turn the call over now to my partner, Larry Hamilton, who, as I hope you all know, is a very experienced insurance regulatory lawyer and heads our insurance regulatory practice, to tell us what happened at last Thursday's task force meeting. Larry.
Thank you, Paul. I'm actually a co-head of the practice along with Kara Basinger, but happy to comment on this. As Paul said by way of introduction, this has had a history going back to July of last year. what the task force did at its meeting on Thursday was to adopt the proposal that had been published on January 27th and exposed for comment at the last meeting of the task force in February, to adopt it as proposed without changes, although also to adopt a long transition period until it becomes effective, which I'll mention in a moment. And just to clarify, I don't think that the NAIC staff, the SVO staff, have used the term abusive to refer to transactions that fall within the newly adopted definition of principal protected notes. So I agree that there were some abusive transactions out there that may have impelled, lent some momentum to this effort. I think the way that to be fair to the NAIC staff and the SVO staff, their concern is that what they regard as the regulatory risks associated with the PPN structures is not being fully taken into account in the investment analysis that the rating agencies are performing. And one can agree or disagree with that, but I just that convey how they view this as requiring the filing of these securities as a way for scrutiny that they feel is appropriate from a regulatory perspective for the holding of these securities by insurance companies. So with that as background, as Paul said, there are multiple parts to this definition of PPN, and in every case, to be a PPN, the following has to be true: that the insurer would obtain a more favorable RBC capital charge or regulatory treatment through a filing exemption and the automatic assignment of the rating agency equivalent designation than if it were to separately file the underlying investments with the SVO. And that's why their solution to this is file this so that we can open up the hood, look at the underlying investments, and come up with our own designation. But if there's not that characteristic of more favorable RBC charge than if you held the components, it's not a PPN. If you have that, then you get this either or that Paul was talking about, which I know he's going to talk about a little bit more. Let me just mention a bit about the transition period, because that's quite important. A long transition period was adopted, and possibly just reading between the lines, I think there was a bit of a trade-off, that the immediate adoption of this at the main meeting was kind of in exchange for allowing a long transition period. Had there not been as long a transition period, there might have been a longer time to adopt, and vice versa. If they'd taken longer to adopt, there might have been a shorter transition period. But this is how that baby was split. The new regime will become effective in 2021 for the December 31st, 2021 financial statements, statutory financial statements. So any PPN that is acquired on January 1st, 2021 or later will need to follow the regular filing process in the Purposes and Procedures Manual of the SVO. Be filed with the SVO within 120 days after acquisition. That's the standard filing schedule for securities that are not filing exempt. Any PPN that's owned prior to January 1st, 2021 will have until July 1st, 2021 to be filed so that it can receive the designation that will be used for purposes of the 12/31/21 statutory financial statements. And maybe this is a good time to toss the ball back to Paul.
Thanks, Larry. I think the devil is clearly in the details in this proposal. The definition, as Larry described, is relatively straightforward. I see the problems that clients are likely to face, however, is really arising as a result of the structure that I described. So you have the objective criteria, again, as Larry described, but then you have specific exclusions. The exclusions cover a couple of cases which they admitted fell into the definition but shouldn't really be subject to this special treatment. Those include defeased or pre-funded securities, which a number of industry comments had pointed out certainly would have met the definition potentially, but really didn't warrant this special treatment. Broadly syndicated securitizations, as I mentioned at the outset, is likely to be a significant exclusion. And then there are some examples of that given, including collateralized loan obligations, and that including middle market CLOs, as well as asset-backed securities more generally. And unfortunately, the NAIC giveth and then taketh away. Because they then take away broadly syndicated securitizations to the extent they are described in the examples which they provide. The examples given are in paragraphs 328 and following of the PPN definition. The first two are essentially relatively straightforward principal protected repacks. In one case, there's a call option on the S&P 500. In the other, it's a corporate investment of some type. Again, they would, even if they were broadly syndicated, it would appear those transactions, if they in fact bear sufficient resemblance to the example, and we'll come back to that point in a second, they would be brought back within the definition and be a PPN and be required, as Larry has described under the new rule, effective January 1st, 2021, to be submitted to the SVO. Obviously, if you have them today, as he described, the transition period would require you to file them within 120 days or July 1st of next year. Then the third example, excuse me, I lost track. The third example is CLO combination note. And a relatively straightforward CLO combination note. This was an interesting case because one of the significant comments made in response to the PPN definition when it was proposed was by an insurance company that has a significant portfolio. And they made, I thought, a number of pretty effective arguments, including that it's somewhat disingenuous to say, well, CLOs as CLOs are okay, but combination notes are not, when in fact, as some of you may know, the rating agency methodology really is the same for each. They look at the underlying cash flows of the portfolios. They then run their stress tests. And so a CLO combo note effectively gets the same rating treatment as it would or had the CLO itself been given. So that was the first argument they made. The second argument is that they made was there's no real evidence of mischief here. It's not clear that there's any evidence that the ratings being assigned to CLO combination notes don't accurately reflect risk. And when challenged, the SVO initially promised us a rebuttal and a response to that particular argument. That hasn't been given. And so at this point, I think the industry comment is right that there's no real evidence that the actual ratings being assigned to CLO combo notes don't properly reflect and fully reflect the risks that are included in them, especially if the methodology is, as I believe it is, to be the same for the CLO itself. Nevertheless, as a result of the adoption of this definition, if you have a principal protected note in the form of a CLO combination note, it will be required to be submitted to the SVO for designation under a methodology to be determined by the SVO. The SVO has been somewhat transparent about that. They've indicated that the methodology will depend on the case, and in the case of CLO combo notes, I think they've indicated it's likely to be a weighted average rating factor or WARF type analysis. But that certainly isn't the complete description of their methodology, and I think it would be fair to say a lot of insurance companies would be very interested in exactly what type of methodology in more detail the SVO is likely to employ in rating these securities. The CLO combination note is, again, a useful starting point for a discussion as well about how close to an example an investment has to be before it's brought back into the definition of PPN. And it would be relatively easy to change a few of the facts that are used in this example, but it's relatively unclear whether changing those facts would in fact result in the SVO at least agreeing that it's no longer a CLO combo note of the type described in this example and now something else. And if it's something else, obviously there's a pretty significant consequence. In the case of a CLO combo note as described in this example, clearly no longer filing exempt has to be filed with the SVO. But in the case of a slightly changed different set of facts, maybe it doesn't have to be submitted to the SVO, and an NRSRO rating would be allowed to determine the risk-based capital for the investment. that may be of no moment unless the SVO rating methodology is substantially different than the NRSRO rating methodology. And if so, they could be very different risk-based capital consequences to having to file with the SVO or not having to file with the SVO. So I think that's what I was planning on talking about in response to the PPN definition, but I think we have a few minutes for questions. So if somebody has a question, perhaps you'd like to unmute your phone if you're able to do it. I wasn't, but good luck. If you're unable to unmute your phone, if you could tell us who you are and let us know what your question is, we'd be happy to try and respond. Before doing that, however, equally, if you're not comfortable with that, you just want to send Larry or I an email, we'll certainly respond to those as quickly as we can after we get them.
And if I could jump in, Paul, this is Larry, it may be that everyone on the phone understands the implications, but just as an example of what would happen because of the filing as opposed to the filing exempt, to take the first example of the transaction in the materials which you mentioned, that's where there's a zero coupon treasury bond coupled with a call option on the S&P 500. The example indicated that the credit rating for that security would be a AAA or AA plus, which would translate into an NAIC 1A on the strength of course, of the Treasury security, and that if the weighted average rating factors were applied by the SVO, it would result in an NAIC 4 or 4B when it includes the exposure to the call options on the S&P index. And the risk-based capital factor associated with an NAIC 1 bond is 40 basis points, 130 for NAIC 2, 460 bips for NAIC 3, 1,000 bips for NAIC 4. So you're talking about a factor going from 40 bips to 1,000 bips, 50x, as a result of that particular structure being filed and analyzed in the way that's indicated in the example. So that, just to give an idea of what's potentially involved. Sorry to interrupt the flow of questions here, but I just want to point that out.
Nope, good point. Anyone have any questions for us?
Hi, Ray Doherty, Bank of America. Can you hear me okay?
We can.
Okay, great. Thanks again for the call. A couple questions. Do we have any idea of the size of the, not necessarily the CLOs, but the equity components, if anybody maybe has an idea of the size there? And do you think that these insurance companies will eventually have to liquidate or move the coupons out because as you mentioned, the 1,000 BIP risk weighting will be too expensive to keep them on the sheet? Thank you.
You're welcome. I don't think anybody has a sense of the size of affected investments. If that was your question, I may have not understood it. But if that's the question, I don't think anybody has a sense of the size of affected investments. I think that was raised as a question early on in the process, but I don't believe the SVO has ever responded, and I don't believe anyone really knows how many of these sorts of investments might be in the books of insurance companies. As to the impact, I think it unfortunately is likely to be very case-by-case driven. Some insurers are clearly more sensitive to risk-based capital adjusted returns. Others may not be, and it would clearly be a thing moving in a very large portfolio of other things moving. Certainly people pointed out that the effect of the proposal might well be a lot of forced liquidation of affected investments, and that would depress prices, and that would be obviously antithetical to the idea of responsible insurance company regulation. I think the response of the NAIC would be, we gave you plenty of notice about what we were doing. We've given you, a long opportunity to comment. We've given you a long transition period before it becomes effective. So you need to just manage your affairs with that in mind.
Okay, thanks very much. And I assume we're all aware of the recent transactions by KKR and private equity shops. So your understanding that these notes would be impacted.
I haven't considered them. I don't know that I have a view as to whether they would. I think that may be a good illustration of the challenge I think industry is going to face. I think you have to first decide whether it's within the objective criteria. So, would you have more risk-based capital had you held the components separately? I think that the answer to that would be yes. I think you'd probably also meet the objective definition of principal protected, the rest of the principal protected note definition. But I think you'd have a pretty good argument that you are a broadly syndicated securitization. However, again, illustrating the point I made before, you're pretty close, if not this, well, you're pretty close to the example in 329, which was the call option on the S&P 500 with a zero coupon bond, except instead of a call option on the S&P 500, you've got, private equity investments. So again, squarely you face the question of, are you the example or not? And, well, I guess the first question is, you're in the definition, are you excluded because you're a broadly syndicated securitization? We've been given no guidance about what that means. However, if you are broadly syndicated, are you brought back in the definition because you're an example? Again, it's not S&P 500 call options, it's private equity. I don't know if that's enough to put you back in or not. I don't think anybody does, actually.
Okay, and I've been hogging a lot of time here. There's no grandfathering, right? I might have missed that if you said it.
No, there's no grandfathering. There is an extended transition period, as Larry described.
Okay, thank you.
Hearing no further questions, again, we encourage you, if you have them, to send us to us by email. Our email addresses are on the webpage and in the invitation. We, again, appreciate your interest in this topic and that you took time out of your day to dial in. So thank you for your attention. I guess you can all now disconnect.
Thank you. Good call.